Hello and welcome to episode 96 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh DeHaas, counsel with the Canadian Constitution Foundation.
And I'm Christine Van Geyn, the CCF's litigation director. Joanna is away today. In today's episode, I'm going to tell you about why you're not allowed to go into the forest in Nova Scotia.
Plus, we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, we're going to talk about the Ontario court decision that found that the Ford government violated constitutional rights when they passed a law to remove bike lanes in Toronto. So this all started last November when Ontario's government passed a law called the Reducing Gridlock Saving You Time Act, which required municipalities to seek approval from the minister before building bike lanes that take away a lane of car and truck traffic, and also ordered the city of Toronto to remove three specific bike lanes that I personally hate on Bloor Street, University, and Yonge Street. So Cycle Toronto, which is an activist group of cyclists, sued the province, claiming that the decision to remove the bike lanes violates their Section 7 rights not to be deprived of life, liberty, or security of the person, except in accordance with the principles of fundamental justice. Life obviously protects life, and security of the person protects your bodily integrity. So the cyclist argument was that by taking away the bike lanes, the government had increased the risk of physical harm like injuries, and that it wasn't doing so in accordance with the principle of fundamental justice against arbitrariness because the government's stated objective of reducing congestion was not correct, that these bike lanes wouldn't actually increase congestion, or that taking them away wouldn't reduce congestion. They also argued that it was grossly disproportionate to remove bike lanes because that might mean that some cyclists would be injured or die. And they were doing this just so that drivers could, get around the city more easily. So the government argued in response that there's no constitutional right to bike lanes. There's no positive rights created by Section 7 of the Charter. This section is there to prevent government action that puts your life or body at risk, not to force taxpayers to provide you with something positive like a bike lane. And they argued that the logical conclusion of this, if cyclists win the case, is that every Highway Traffic Act decision would potentially violate the Charter. And I'd strongly suspected that the cyclists would be laughed out of court, even though they won an early injunction to keep the bike lanes in place until the case was heard. But Christine, I was wrong. Justice Shabas, who's the same judge who upheld the discipline of Jordan Peterson, sided with the cyclists here. He found that the evidence is clear that restoring a lane of motor vehicle traffic where it will involve the removal of the protected nature of the bike lanes will create greater risk to cyclists and to other users of the road. Justice Shabas also found that this violation of life and security of the person was arbitrary because the evidence showed that restoring the lane for vehicular traffic will not, and I repeat, not reduce congestion, despite the government saying that it would, and common sense suggesting also that it would. So this was, of course, all based on expert evidence, and the experts here were people that advocate for more bike lanes. But the judge said that they're not biased, and also that they're right, that taking away a lane from cars on a busy street and handing it over to cyclists somehow does not reduce congestion. So I have to say that, setting aside for now the fact that the decision does create a positive right to these bike lanes and also interferes with democratically created policy, it makes me angry that people continue to claim that taking away a lane of vehicular traffic and replacing it with bike lanes, which are not used for, half of the year, somehow reduces congestion. And, that's because I have eyes. I travel on these bike lanes or these streets all the time. And immediately after the bike lane on Bloor Street opened and a lane of traffic was taken away, my drive to Yorkville, that part of the city, went from about 25 minutes to like 35 or 40. They put one in on Danforth, and immediately after, it felt like I'd It took, twice as long for me to get to Home Depot. And you talk to Uber drivers and they'll tell you the same thing. Like when you reduce some of the biggest streets in Canada to a single lane, you're not reducing congestion, you're creating congestion. Justice Shabas, however, did buy this claim from the experts that reducing road capacity for cars will reduce congestion because it will encourage biking, and that if you do the opposite, which is now remove the bike lane, that those people who had switched to cycling will switch back to cars. I don't buy that, but in any event, he also doesn't account for the other costs, which the province presumably was accounting for in their policy rationale, such as the harm caused to people who are forced to sit in traffic longer each day, which is, bad for your heart and your cardiovascular system. And anyway, Justice Shabas pushes back at this claim also that this is creating this positive rights to bike lanes. He says that, rather where the government takes action that puts people at risk and does so arbitrarily, its actions can be restrained under the charter. He points to a few cases, including CanLii, where the Supreme Court found that Quebec had violated Section 7 arbitrarily when they blocked private patients from contracting with doctors for care, leading to their pain and suffering. But CanLii was not about telling the government how to allocate scarce resources like road space or set its traffic policy. It was about saying the government can't use a law to arbitrarily block two private people from contracting with each other. So that was not a positive rights claim, whereas this is. And Justice Shabas says at paragraph 155, governments may take steps that may put people in harm's way by removing something, but they can only do so if their actions are in furtherance of a legitimate policy decision. So in his view, it's up to the court to decide what's a legitimate policy decision. Isn't that what we elect politicians for? Isn't that why Doug Ford ran on this policy and won this huge stomping majority, because people actually mostly agree with him about the bike lanes? And this really does keep a right to, keep these bike lanes in place, which is a positive right, unless the government can convince the judge that there's a good enough rationale in the judge's mind for removing them. And it is going to open the floodgates to all kinds of other positive rights claims and demands that courts set policy using Section 7. So, what about the speed limit? The province recently raised the speed limit to 110 on a bunch of roads, another decision I personally agree with. But obviously that's going to lead to some marginal increase in deaths. Like it's just, there's 16 million people. If everyone's driving a little bit faster, that will cause some deaths. But, on a province-wide scale, that's also going to make the lives of millions of people who drive marginally better. So how do you weigh that cost? Well, that's up to politicians to weigh. But now, if you're a road safety advocate and you want the speed limit to be 90, you can just go to the court and say this is violating rights because some number of people might die as a result of the speed limit having been raised. And what about safe supply of opiates? There's lots of people that tell you that prescribing opiate pills to fentanyl addicts will help them get off fentanyl, which is a more dangerous drug, arguably. And so this policy is saving lives. But other people argue, well, you're flooding the streets with these pills, creating new addicts, and you're prolonging addictions that lead to crime when treatment is the answer. These are things that governments are supposed to decide. But now, if the government tries to kill that safe supply program, I'm pretty sure we're going to have a charter challenge. Now it's going to look like it's going to be a lot more likely to succeed. So the government has already said they're going to appeal this decision. So we'll see what the Ontario Court of Appeal will have to say about this. Christine, I know you ride your bike a lot, and so you don't have any issue
As is my
with
constitutional right,
with these
apparently.
with these bike lanes in particular. But what do you think of the reasoning here? And do you think there's a strong chance it'll be overturned on appeal?
I mean, if this isn't a positive rights case, I don't know what is. Like, it's the same as that case Mather from the Ontario Court of Appeal that we talked about a few episodes ago. This constitutional right to a specific climate change target. I just don't know why these judges think that this is their job. These are people, if you like policy so much, go and run for office and create public policy. That's not the role of a judge. And like, stop making me have to defend the Ford government. I don't want to have to defend Doug Ford and the crazy, dumb things that he does. But like, if he wants to take out the bike lane, I think he has the power to do that. And there's not a, I don't think, a viable charter argument to a specific type of infrastructure that you like better. Like, I use that bike lane, but I don't think it's my constitutional right to use a specific bike lane. When the charter was enacted, this is not the kind of thing that the creators of the charter had in mind. They were thinking about prohibiting um, religious and racial discrimination, not an entitlement to a specific type of road. But let me move on to my news take or my news headline. It's about this is bizarre story from Nova Scotia where the government has banned walking around in the woods. So the province has announced that they are banning hiking, camping, fishing, and the use of vehicles like ATVs or I guess little motorbikes, and they're banned in the woods. And they say that this is due to an elevated wildfire risk. So, yes, there are dry conditions in Nova Scotia. There have been really devastating wildfires. I think a really terrible one in 2023. And preventing wildfires is the job of the government. It is important, but this is obviously overkill. Walking doesn't cause fire. Like, I don't know what kind of walking is causing fire, but it doesn't cause fire. Um, a fire ban, totally reasonable. And that type of thing is normal. We have fire bans all the time across Canada during dry seasons. But walking, fishing, these things do not cause fires. And by the way, the fine, if you do go walking around in the woods, take your dog for a stroll, the fine is $25,000. So that is one expensive dog walk. This actually is not the first time that Nova Scotia did this. They did this in 2023, and apparently they have a history of doing it. They did something similar in 2016 and in 2001, but when they did it then, in 2016 at least, the fine was $180 if you were caught hiking, not $25,000. The 25,000 thing is especially egregious. So I looked into this a little. Crown land access is one of the few exceptions that we have to otherwise, pretty good protections for private for property. This is crown land. It makes up a large part of the land in Ontario. And restricting access like this is just a huge overreaction, even given the seriousness of wildfires, because this is banning an activity that does not cause fire and where people are not, at risk of being caught or stuck in a fire. So, because the fires are not, they're banning walking in the woods where there are no fires. Obviously, you shouldn't go walking in the woods in the middle of a forest fire. That would be a reasonable thing to prohibit. So, I looked into this a little bit because we've talked about this notion of the right to roam in a few other episodes. So this is an English common law concept, and it refers to the public's ability to access certain lands for walking, hiking, recreation. And it actually even applies in ancient English law, even to privately owned land. Now, this has evolved to, in England, include statutory rights, including a piece of legislation in England called the Countryside and Rights of Way Act. And that grants a more limited now in England right to roam over mapped access lands, including, these English phrases, mountain, moor, heath, and down, as well as on some registered common lands. And in England, in these lands, the public has the right to walk freely. Now, Canada is different, but we do give access to Crown lands. Crown land in Canada, as I said, it makes up a big part of our land. It is about 89% of our land is Crown land, and most of it is managed by the provinces. And in most provinces, you can access Crown land for recreation, things like hiking, camping, fishing, hunting with a license, canoeing, foraging, climbing, things like that. But you in Canada, you don't have a general unqualified right. access is granted and controlled by provincial law. It's not this treated the same way as it is in, for example, Scotland, where they have this very broad right to roam, and as I understand in Sweden as well. Now, in Canada, roaming and camping on crowned land is a regulated privilege, but just because it's regulated doesn't mean the government can exercise that regulatory authority with absolute unfettered discretion. So, in Canadian administrative law, we talk about this term discretion, and it refers to the ability of a decision maker, like the government in this case, or sometimes it's a tribunal, sometimes it's a board, but here it's the premier creating this proclamation. And discretion is the ability to choose between different permissible outcomes or options when making a decision. And that discretion isn't unlimited. It needs to be exercised lawfully, reasonably, and fairly. And it needs to be exercised within the bounds of the law and for the purpose intended by the statute, in this case, the Forests Act. It needs to be exercised reasonably. It must be justified, transparent, and intelligible and reflect a rational chain of reasoning. That comes from a decision called Vavilov, which we've discussed on this show before. So it can't be based on completely irrelevant factors. So here I think there is some vulnerability for under these administrative law standards to this ban on going in the woods. So the ban is, as I said, through a proclamation under the Forests Act. I looked up the Forests Act, and one of the purposes of this Forests Act is to prevent and mitigate wildfires in a changing climate. And good, valid purpose, but there's just zero connection between walking and preventing wildfires. Walking, as I said, doesn't cause fire. And to make some deduction that when people walk, they might also at the same time do something bad that causes a fire, that's just too much of a stretch. It's like saying, people can't drive their cars because when they're driving their car, they might also veer onto the sidewalk and intentionally run people down. Or people can't walk on the sidewalk because when they walk on the sidewalk, they might walk up to somebody and punch them in the face. You can ban the dangerous activity while allowing the normal, safe activity. So anything else is irrational, and it's couched all in this terrible ideology called safetyism. So safetyism is this mentality where risk of anything becomes an excuse for government control. It's safetyism is this belief that safety, protection from physical or even emotional harm in some cases, that it should be prioritized above everything else, even at the cost of other fundamental values to our civilization, like freedom, autonomy, or even open debate, or I guess walking around. So it often starts with good intentions, protect people from danger, here, fire. But when safety becomes the highest value, governments begin to justify extreme restrictions, all in the name of protecting the public. And it creates a culture where any risk is seen as intolerable. So the risk of walking is just so unsafe that we need to ban it. Where dissent is viewed as dangerous, where state control becomes normalized because it's for your own good. So once you see that this kind of overreach is workable, then it's replayed over and over and over again every few years. And that's what we're seeing happening in Nova Scotia. Now, I've actually got a report coming out next week on cases where governments have used safety to justify all kinds of overreach, the worst examples of safetyism as a justification for overreach, and how policies like those and like this one can expand if they are not checked. So that report is coming out early next week. And if you sign up for our mailing list at the ccf.ca, you'll get a copy as soon as it comes out. Now, after your talk, description of your case today, Josh, I want to go for a bike ride. Do you feel like going for a hike after hearing my little discussion? You don't have a constitutional right to hike, but you do to bike.
Yeah, I don't want to do either right now because there's actually forest fire smoke in the air and the air quality is too bad to go outside. So I do recognize people that, obviously forest fires are a serious risk and we can do things to mitigate them. And, for fire bans while camping really suck. They really do. But the solution to that is not to ban camping or to ban fishing or to ban picnicking or to
Walking,
ban
walking.
walking, merely being in the woods. Like, people have a right to roam. They have a right to physical liberty. They have a right to not have governments arbitrarily take away all of the things that make life worth living for months at a time because it will, slightly reduce the risk supposedly according to the premier. Like, to look back to the highways example, if the speed limit on the 401 was 10 kilometers an hour, there would be lower risk of people dying in car crashes. But it would make life unbearable, and the same sort of principle applies here. Like, there has to be some serious risk of fire from the activities you're banning. So I really hate this. I hope we find some way to push back against it, and I think that's all we should say about that. Let's take a break, Christine. When we come back, we'll give some more bad legal takes. Everything is a bad legal take today. Okay, so I'll go first. My bad legal take goes to the Ontario Crown Attorneys Association president for a statement, apparently in response to comments made by politicians criticizing the Crowns who sought 7 to 8 years in prison for Tamara Litch and Chris Barber, who were convicted of encouraging mischief, and in Barber's case, also ignoring a court order, and a bad Toronto Star opinion piece that we already talked about criticizing the Crowns in the London hockey player case. The most high profile of the criticism was from conservative leader Pierre Poilievre, who tweeted, "Let's get this straight. While rampant violent offenders are released hours after their most recent charges and anti-Semitic rioters vandalize businesses, terrorize daycares, and block traffic without consequences, the Crown wants 7 years of prison time for the charge of mischief for Litch and Barber." So this prompted the press release from Crown Attorneys Association President Donna Kelway, who wrote, "Personal attacks on Crowns seeking a significant sentence are nothing less than attacks on prosecutorial independence. Be they attacks on prosecutorial independence or sexist attacks on principles of fundamental justice, these actions are affronts to the rule of law." But how can Pierre Poilievre, his statement criticizing these extremely long sentences being sought, be an attack on their independence when he's not the PM, he doesn't hire Crown attorneys, he's not the minister, that's not even his jurisdiction, right? This is the province that hires the Crown attorneys. Does Kelway think that politicians are never allowed to criticize citizens because of potentially excessive sentences for crimes committed by political protesters? Does does she think politicians couldn't, for example, say that, Black or Indigenous offenders get sentences that are too long considering their over incarceration rates? I mean, somehow I think she might be fine with that. So, of course, politicians should be allowed to comment when they think that sentences are unjust. This isn't a case where the Attorney General or the PM is directing the Crowns to seek a particular sentence against a particular person, which would be a problem for the rule of law, but this just is not, and that's why this statement is my bad legal take. Christine, let's hear yours.
So, my bad legal take I want to use to talk about bubble zones again, one of my favorite topics. So, my BLT goes to the Quebec courts for their recent decision upholding bubble zones in that province. So, I fundamentally disagree with these laws. I think that they are one of the fastest evolving censorship tools that we have in Canada. I think they are a real threat to freedom of expression. So, the decision upheld these bubble zone laws in Quebec. I disagree with the decision. It was related to a challenge to a bubble zone law around abortion clinics, where there was a 50-meter bubble zone prohibiting protests near abortion clinics. So the question was, do they violate the right to freedom of expression? And if they do, are they justified limits? And the court found that they were a violation of the right to freedom of expression and assembly, but they concluded wrongly, I think, that they are a justified limit. So the court found that access to abortion free from harassment or intimidation is a pressing and substantial objective, that the bubble zones are rationally connected to the goals of access to the clinics and to privacy. And they held that a 50-meter perimeter is minimally impairing and that the restriction on the rights to expression and assembly are proportionate to the goal of providing access and privacy. And I disagree with basically every part of the Section 1 justification analysis. I'll just say one thing at the most fundamental level in Ward in Quebec, the Supreme Court case on freedom of expression and limits to it, the court held that mere psychological, mental, or emotional harm is not a pressing and substantial objective for limiting speech in a free and democratic society. And that's really what we're talking about in this case. They call it harassment and intimidation, which are already criminal offenses. If those were what the concern was here, there would be those would be addressed using the criminal law. We're talking about emotional safety here, and just as that's what was at issue in the Ontario version of this case, or so the Ontario version of this case dealing with an injunction, a case called Dealman. Now, Dealman, I've written about this in my paper for the Macdonald Laurier Institute on bubble zones. The law has been clarified since Dealman, and under Ward, preventing emotional discomfort cannot be a pressing and substantial objective, even if the speech does make us, including me, uncomfortable. That is not a valid reason to limit speech, even speech we don't like. So that's my bad legal take to Quebec, and I hope that this gets appealed.
I agree. All right. Well, that's the show. As usual, if you haven't already, please do review us on the podcast app, subscribe, comment on YouTube if that's where you're listening to this show. And you can support our work by subscribing to our YouTube channel, by following us on X, or by visiting our website and signing up for the Freedom Update newsletter. The CCF is a nonpartisan legal charity funded by your donations, so please do donate on our website if you can. Thanks for listening.